Are verbal contracts legally binding? Many people assume that for an agreement to be enforceable, it must be written down and signed. But the truth might surprise you. Verbal contracts are typically legally binding if they meet core elements of contract law. In fact, very few contracts are actually required to be in writing to be valid. As long as a verbal agreement is reasonable, fair, and made in good faith, it generally has the same legal standing as a written contract. For a verbal contract to be binding, it must include several key elements. There must be mutual consent and understanding between parties. One party must make an offer that the other party accepts. Something of value must be exchanged, known as consideration. Both parties must perform their agreed duties, act in good faith, and have a lawful purpose for the contract. The terms must be clear and complete, and both parties must freely consent to the agreement. Despite their validity, verbal contracts do have significant limitations. Under the statute of frauds, certain types of agreements must be in writing. These include contracts involving real estate sales, agreements that cannot be completed within 1 year, promises to pay someone else's debt, contracts involving marriage as consideration, and sales of goods over $500 under the Uniform Commercial Code. One of the main challenges with verbal contracts is enforcement. Without written documentation, proving the existence and terms of a verbal agreement can be difficult. If a dispute arises, it often becomes one person's word against another's, creating a legal impasse for the court. However, verbal contracts can be supported with various forms of evidence. Performance of duties can demonstrate an agreement existed. For example, if someone mowed your lawn after a verbal agreement, that action supports the contract's existence. Payment records, witness testimony, and related correspondence like emails or text messages can also help establish the terms of a verbal agreement. State laws regarding verbal contracts vary across the United States. California recognizes verbal contracts but requires certain agreements to be written. New York strictly enforces the statute of frauds for real estate and agreements lasting more than 1 year. Texas allows verbal agreements but emphasizes the importance of performance to establish enforceability. Statutes of limitations for filing claims based on verbal contracts typically range from 2 to 6 years, depending on the jurisdiction. While verbal contracts can be binding, they present higher risks for complex or high-value transactions. Best practices include following up verbal agreements with written summaries, keeping records of any related payments or communications, having witnesses present during the agreement, and using written contracts for significant deals. Verbal contracts can also be implied through actions rather than words. When you purchase items at a store, you enter an implied contract to exchange money for goods without explicitly stating the terms. In summary, verbal contracts are generally legally binding when they meet the requirements of contract law, though certain agreements must be in writing under the statute of frauds. While enforceable, verbal agreements can be challenging to prove in court without supporting evidence. For important matters, it's always safer to document agreements in writing, even if just a simple summary signed by both parties.